Good morning, friends. This is with regard to the Nagpur land deal. This took place during the period of 2012. And I will just give you the background because this matter has come before the Honorable Supreme Court, Madras High Court, day before yesterday, before Dr. Honorable Justice Anita Sumant Madam. And the Honorable Anita Sumant Madam directed the institute to file their counter. Nobody were present for the institute and gave January 3rd as the last date. That's the point. And their lordships also asked me to submit the suggestions, if any, which I'll read out. And therefore, I would like to brief this matter, the entire background to this matter, so that if any of you, many of the members, experts who are concerned about our profession are coming forward to give some suggestions how to strengthen the mechanism of the institute functioning, particularly because our institute is Honorable His Excellency Abdul Kalamji said that institute is a partner in the national building. And that means we are Act is 1949. That means it has come before the Constitution was adopted by the nation. Therefore, it is such an important institution in the eyes of the nation and the legislature. But over a period of time, you will find the powers of the institute are being taken over by the government, and now NAFRA has come to oversee. So, what exactly is the problem? See, the entire institution, the corporate governance, the transparency, the public confidence is the oxygen for the independency. And we know we have the best of the examination system. And therefore, what exactly is the matter? I'll just brief you shortly, but I would like to take you through the documents so that you will know what exactly has happened. The sum and substance of the matter is this. During the 2012, Mr. Jaidip Narendra Shah was the president of our institute. That means 2011, he was the vice president of our institute. So what happened is they entered into a deal with somebody, and they paid 100 crore is the project, excellence, business excellence project in Nagpur. So there is nothing wrong in starting business excellence projects. It is in the interest of the institute and the future of the members. But the problem is that the president, Mr. Jaidip Narendra Shah, and Mr. The secretary, Mr. Karthikeyan, and the vice president, then vice president Subodh Kumar Agarwal, all these three people, what they did is they gave a contract to one company called Luxora International. Mr. Jaidip Narendra Shah is from Nagpur, and Luxora International is a builder from Nagpur. This company was formed 1 year before the entering into agreement, and their sales for the previous year was zero. But the contract was entered into, but 10 crores was paid, and the deal is finalized in a short span of time without informing the council. The council has met before entering into it, after entering, and 2 months, nothing happened. So you can see the way in which things have done. The allegations have come. The Economic Times and other papers started publishing based on the reports received from the members and all. And that was a period of election to the council. Therefore, whenever these people, the contestants went there was a hue and cry about the way in which institute is functioning. So therefore, naturally, for getting votes, these people have to react, and they came back. And then there was a 320 meeting was conducted. But now today that is coming to a shape after 9-10 years of time. But I will try to bring you the background. The first step is that this thing happened was known to one Mr. Prabhakar, chartered accountant. He was the editor of Society of Auditors, a very dynamic person. And he informed me that there is a big scandal has taken place. Why don't you file a petition? Because I was filing earlier for the this annual general meeting to be conducted by complying with regulation 150 of CA regulations. Then I filed another petition for education system when 40,000 students have been failed, and there were a lot of mistakes in the examination papers. And then that was also, though the petition was dismissed, the problem raised was solved, and it has gone up to the appeal stage. And then there was a lot of appreciation for the hard work done by us. But Prabhakar wanted me to take up the matter. Then I was scared because it's the matter making allegations against the presidents. Then an enormous institute you all know, they will crush you to size. And we are all small people. Then Prabhakar went and requested M.R. Venkatesh, Dr. M.R. Venkatesh, my student also. He's also a very dynamic person. Now he's become advocate. He was asked to, he wrote this thing in Read If Mail, very beautiful article. So I thought, okay, there's something correct because it is not something which I'll get into trap. Thereafter, Mr. Gurumurthy, chartered accountant, shocked by the way in which institute is functioning, wrote a letter to the council saying that what was the tearing hurry with which you are all doing like this? If you do like this, the institute will be in trouble because slowly and steadily you will lose all your powers. The integrity of the institute is highly respected because of the independence. It's a self-regulatory body. And if you start doing like this, the government may come in through CAG audit and then take over. After seeing that, I filed the petition, and the petition came up before Justice Honorable K.K. Sasidharan, and the institute engaged senior counsels, former advocate generals like Mr. P.S. Raman, Mr. Vijay Narayana, and a host of lawyers. The institute engaged Bombay lawyers to come, and Chennai lawyers, Delhi. It used to be 30, 40 people used to appear. And I was very new to this court proceedings in 2011, 12 and all. But then I was quick in learning how they are approaching these things. For that, immediately I used to read and get the answers. I tried my best, whatever to happen. Then what happened, Mr. Prabhakar got some AGM 32, 320 AGM minutes of the meeting from some council members. Then that way he published in the Society of Auditors. And then during that day hearing, it was slated for hearing from 10:30 to 1:30. And they were arguing for almost 2.5 hours, the senior counsels. The senior counsels were naturally, they are so senior, they were attacking me personally because they were telling disciplinary case has been, he was found guilty. I was found guilty because Mr. Bhupati filed 4 cases against me. Disciplinary case, criminal defamation case, civil defamation case, and they removed me from classes. And so they used that. I was defending them. I don't know anything about law. And using that, they were telling this man found guilty for misconduct. Therefore, the institute has taken action. And aggrieved by that action, this person is filing cases. So they stand. Actually, it should also wanted to ensure that no other person comes like me, because we are all busy with our work profession, and anything happens, they will attack you, then you will lose everything. So inherently, there is no scope for any member to get in. But I thought, okay, even I am attacked and all that, let us do something. And if it is going to be productive for the institute, even I'm in trouble, that's okay. We'll manage because I was a teacher, I can teach and take classes and then leave. That was the attitude of mine. Now, let us proceed with regard to few points in this regard. And this is the council meeting, hot meeting was there. CA Pankaj Jain suggested that all these matters could be looked all over. CA Jain Gokhale stated that it was not a matter of Nagpur deal, but the question is that of governance in the institute, which prescribes governance norms to others. Beautiful point. He stated that if the council was shown to be deficient, then it will lower the image of the entire profession in the eyes of the public. He stated that it was not a matter of few lakhs of rupees, but 97.5 crores. He stated that if there was any doubt in anybody's mind as to whether a certain thing can be done or not, then prudence demands that it should be referred to a higher body and not decided by President alone. So it is very clear from this, it's Jaideep Narendra Shah himself has decided. Referring to Regulation 176.2 regarding powers of the Finance Committee, he stated that Council had the power to review any decision taken by the Finance Committee. He stated that it was rightly pointed out that Finance Committee never had any power to procure infrastructure. But having done that, it should have come to the Council for prior approval. He stated that if things go on in this manner, the government will step in and perhaps he and AG will step in to do the audit. Particularly because there is a view that chartered accountant being a member of the institute cannot audit the accounts of the institute. He questioned as to whether the members are aware about the track record of the company with which the institute has dealt with. He stated that in big booklet circulated relating to Luxora infrastructure, the said company did not have a single rupee of sale for the year ending 31st March 2011. He stated that he has checked up with the antecedents of the company and found that even during the year prior to that, there were zero sales. And you will now go to this end. Questioning whether the due diligence claimed to have been done by the office, he pointed out that the CEO of that Luxora, CA Sanjay Kotari, is a full-time employee and is also holding full-time COP, and the president of ICAI entered into an agreement with him. He stated that if we have to preach governance to others, then the others will be waiting to get back to us. He stated that one should have been extra cautious in these matters. And the approval, they stated that 25th July, the date on which it is approved. And thereafter, on 30th July 12, the Finance Committee has given an in-principle approval to the matter. He stated that 1st August 2012 had been a very busy day for the Institute when title clearance was obtained from the company's lawyer. You see, that company's lawyer they have taken. Vetting of the draft was done by the Institute. 3 demand drafts were obtained within the banking hours before 3 p.m. And he stated that all these actions were completed between 10 to 3 on 1st August. And on 2nd August, some people traveled to Nagpur, and on 31st August 12, the agreement was executed. Knowing fully well that in the next 10 days, the council was about to meet. The president could have waited for 10 days to obtain the approval of the council. He stated that council met for 3 days on 13th to 15th August, when there was not even a whisper of the deal having been entered to. Further, on 22nd September 12, the council again met to consider the annual report and accounts, when again there was no whisper about this deal of such high magnitude. He stated that a member has written that when every decision has to be taken by the president, then why 32 council members were required? And this was written by Mr. Gurumurthy to the council, which they have recognized. He stated that this is a question whether the council members will have to answer, that if powers vested with the council members were 32 council members were required, then that's very important point, that when every decision has to be taken by president, then why 32 council members were required? He stated that this is a question which the council members will have to answer, that if powers vested with the council have to be exercised by the president, then why should the institute need a council? Such is he once again asked the secretary to explain to him if any tabulation of responses had been done, whether any ranking was done subsequent to the tabulation and comparison of others. The secretary, you see, let's go ahead. Who is the official passing the orders and all? And you all know that the secretary was a joined the institute as a clerk, storekeeper, and with his PRO skills and all, he became very big. And you see how he's replying to the president. You see this regarding this thing. You see here, the secretary, while pointing out that several accusations have been made against the office and also personal against him, stated that instead of countering those allegations, he will submit the role of the office is not to go behind the intent of the proposal of the committee to see whether the proper procedure is followed. See, here I'll just take you to the 1 minute. So now, friends, you see his reaction. He stated that as far as governance was concerned, he can well govern himself and regulate himself and does not like anyone to advise him about the governance. He stated that if he started asking for governance, he can come out with list of governance areas where even everyone was lacking, but still the office has been closing its eyes. He stated that he can list down number of governance issues lacking based on his association for more than 30 years in the institute. And you can see he requested that he may not be advised on governance because he can teach governance for hours and can quote instances of misgovernance. Stating that he does not want anybody to teach him governance, he stated that there was no need for any member to point out that he should proceed on leave. He stated that he has already mentioned several times in the council table he wants to get relieved from the position of secretary as he was finding it more and more difficult to work in such circumstances. He stated that he has made his position clear and was open to any kind of investigation. You see, friends, this is an institution which was established under the 1949 Act much before the Constitution came into existence. Point one. And there is a clear-cut misgovernance. It's not misgovernance, misappropriation of money. And procedural, all things have been flouted, and the money has gone. For 10 crores of rupees have gone from these things. Now they are trying to say claim back and give back the money. And now who is responsible? On one side, president is sitting and chairing that meeting. And another side, the secretary, who is the person who released the money, saying that I care nobody. And warning the presidents and others that he will take them to task. And this, you remember, the secretary retired only in 2017 or something. It is under 2011 it has happened. That means institute could not find anybody. And naturally, the government is upset. And Honorable Prime Minister exactly came and told on 1st July when he took over, what's wrong with the CA institute, he told. Now, the sum and substance of this, as you can see, the institute is working under the dominance of one person, one that is called as the president, the chief executive officer. He is deciding. Any trouble is there, he says, council decided it. The council followed by vice president. The vice president will take over as the president. So it is something completely, what will happen to the public if they go through that? And now second question arises to all of us is, what were they doing? And now you see, this is what I read out to the court. And on that day, I was there, Prabhakar was there, and the judge was shocked. And he told the councils of the institute that something should be done, bring all the records. And before that, see that money is repaid. So out of 10 crores of rupees taken, 7 crores they paid. 3 crores stamp duty not paid. And the institute is defending with their money these delinquent presidents. Institute funds, lawyers are fighting. And more than 3 crores have been spent on these people till date. And every time they'll tell me, I am found misconduct. What about these people? My misconduct is I wrote wrongly about Bhupati. Bhupati himself has admitted in the cross-examination. And so, what is the law? Are we governed by rule of law? That is the question. Anyway, now after the, I'll show you what's the order passed by the Honorable Madras High Court. Even after that order has been passed, what did they do? Did they correct the system? No. Did they take action on Jaideep Narendra Shah and other delinquent persons? No. Did the auditors point out all these things? No. Did the money is received? No. And they're happily going on. Now that is only 7 crores. Recently, when the government asked for 10 crores, Atul Gupta ji has paid 25 crores. Who has got all these things? So this is the issue that is coming up before the Honorable bench of Madras High Court. Now you see, I will show you. Then they wanted this person. Then President was asked. Then President also said, okay, you want to find inquiry against me? You start it from 2012. Because all other presidents will come in, and council comprised of all, disciples of these presidents. Therefore, what is going to be expected? He knew it. He was prepared, saying that if you are going to take any action, then let that inquiry start from 2002. Then we will see. And I'll reply to that. 2001. Because the other big people are already there. So Institute immediately said, okay, we'll cancel the contract. And then that's all. And what happened to my case now? The Institute, first I filed as a bill. And it came before Honorable Acting Chief Justice Dharma Rao. And he dismissed that, saying that it's not a bill. Because I'm a member of the Institute and I have a personal interest. Immediately, Institute published in that report, there was a report, and the Honorable Madras High Court dismissed the petition in limine because they wanted to cover up that entire matters. Then I, myself, Prabhakar, we again filed before the single judge because he said personal interest litigation. It came before Honorable Rajeshwar, Justice Rajeshwar, sir, and it was admitted. Then the case started, and these arguments were there the last day. Then came the judgment of Honorables. This was the 13th October. KK Sasidaran Justice and Venkat Shivakumar Institute, Shah Jaideep Narendra, Agarwal Subodh Kumar, etc. is there. Bhupati and Ved Jain and others were there. Then the judge itself, because I didn't know much of law, so I didn't implead CBI. Though I asked for relief against that, they have impleaded, and you can only see this is this writ petition is at the instance of Venkat Shivakumar, Chartered Accountant, seeks a writ of mandamus directing the Central Bureau of Investigation or the Central Vigilance Commission to investigate and unravel the irregularities, conspiracy, and criminal breach of trust committed by the President and the office bearers of the Institute of Chartered Accountants MTR. More particularly, the purchase of land building for the crores, 90.7.5 crores for establishing Center of Excellence at Nagpur at an exorbitant prices, and the scandal reported in the newspapers. The writ was heard, and thereafter I have reserved it for orders. I have perused the records produced by the Institute of Chartered Accountants of India. The minutes of the council meeting and related proceedings certainly contain details as to how a statutory body like the Institute of Chartered Accountants is functioning. The Institute of Chartered Accountants is supposed to be an apex body to regulate the affairs of the body and to monitor the functioning of its members. It also exercises disciplinary jurisdiction over its members. In case the apex body itself violates the financial discipline, it's really a serious matter. The records indicate that all is not well with the statutory body. The council members have expressed their strong views against the president and the secretary on account of entering into certain financial dealings without taking the council into confidence. The transaction is not confined to the Center of Excellence at Nagpur. There are other land dealings also involving substantial amounts. The president took the stand that there cannot be a difference. So he was telling something in that this thing. And it is true that Nagpur land deal was cancelled on account of the protest by council members. However, that could not put an end to the issue raised by the petitioner. The issue raised by us is you correct the system. If so many things will happen, what happens over a period of time, the CA itself will become redundant and somebody else will take over. This is an institution established by the parliament, and for one or two such delinquent president cannot be there. Now, then the case was not coming up at all for hearing, and nothing happened. Nothing happened. We wanted to bring it to the regional council discussions, regulation 150. We moved some resolutions for discussion, and M.R. Venkatesh moved, Prabhakar moved, I moved, but Institute refused to listen to them. And there was a specific direction from the division bench that you have to strictly comply with that. So, when you see that, you please see how the petitioner earlier filed writ petition before this court for writ of mandamus, directing these respondents to convene annual general meeting of Southern India Regional Council, including the resolution submitted by him. The writ petition was dismissed. The order dated 15th February 12 in 14/16/50 was taken up before the division bench by way of intra-court appeal. The division bench, while disposing of the intra-court appeal, the division bench, while disposing of the writ appeal, granted liberty to the petitioner to approach this court in case the first respondent fails to follow the regulations. The petitioner thereafter filed this writ petition for a direction for this first respondent to convene the 61st annual general meeting for a direction to the first respondent. Then they have not, they have rejected again. And then again, the matter, they did not take up the AGM itself. And then what I did, I again moved that. One more miscellaneous petition I filed. See how the judges felt their order. The petitioner only wanted the regulations to be followed in the matter of conduct of meeting. Regulation 150 provides that a member of this region shall be entitled to move any resolution for the consideration of the meeting of the members, subject to the condition that the draft resolution is received by the secretary of the regional council at least 28 days before these things. The chairman was given the discretion to admit the resolution even at shorter notice. See, here the chairman has been given full powers, and all were rejected. And you see, the sixth para you read, the first respondent is a statutory body. The Southern India Regional Council was constituted by an act of parliament. Regulation 150 very clearly provides for circulation of draft resolutions. The petitioner has produced the draft resolutions forwarded by him to the first respondent. In spite of Regulation 150, the respondents are not prepared to entertain the resolution admitted by the petitioner. The attitude of the first respondent is unreasonable. In view of the adamant attitude taken by the respondents and their decision not to entertain any resolution by the petitioner, I am inclined to pass the interim order. So now, friends, you can all see that the sum and substance is that the institute is not willing to address the basic issue. And the writ petitions were pending. I'm filing so much of cost, and it's difficult. Time spent is very high. And as if there is a feeling that I am bent upon attacking. No, I don't want, I have no personal interest. I'm a teacher. In what way? I'm really worried. But the students' future, the members, which member can really take up my friends? The institute will immediately attack them. And fighting against institutes is just impossible. They will appoint people with topmost these things. They will talk anything, and we will not be able to match them. So this is the recent came on 14th. At 12th, the matter came up for hearing. And this honorable judge is extremely good. And the madam is a PhD. And the Lordship knows all the areas of taxation, company law, internal audit, audit standards. She very good. Therefore, and then, this according to law, they have no fear or favor, and intellectually ability to understand the issue and also find solution. It was just a bad luck for the institute or good luck for us. It has come. Now, it has to be solved before this bench gets off. Of course, others may be also better and all, we don't know. But when something is going, let's complete it. Now, this was heard and institute was not represented. The petitioner will also circulate a scheme containing suggestions touching upon proper and transparent functioning of the institute. See, now it's very clear, friends. From the reading I showed to the honorable judge lordships, that here is the situation where it is an institute governed by 32 plus 8. But then we see that is the president is calling the shots. But when anything accountability is coming, he is telling council. So it's like a good cop, bad cop type of things going on. Till date, no action is taken. Suppose this honorable court decides to punish, ask for inquiry or something as prayed for, they will file an appeal and then get the stay, another 10 years. Legal costs will be additional burden to the institute. The honorable judge asked, what happened to the 3 crores? They have not come, my lords. Already another 3 crores is spent. So that means whose money is this? This is institute money funded by CA members and students. So visibly, they were determined to do. I have explained them. We'll have to correct the system. Today, another man will come. 2 problems are there. One is the delinquent fellow will make use of the system and make good money, and other good persons will be watching, and they will have nothing to say because this is not a crusaders. Accidentally, I have become a crusader at the cost of these things. So then lordships asked me, can you suggest? Yes, we are ready with Pakka suggestions. Actually, friends, we should realize that all the toughest problems have simple solutions. And here, there is no problem. You have to make the chairman of the regional branch responsible. That means responsible means the court must pass. For compliance of 150, it is the chairman who is given power there. And he is responsible, so that he won't blindly decide. Suppose if say central council also will take back, president is responsible. Here is the regulation. The member is passing, bringing resolution, you have to pass it. Otherwise, you amend that 150 regulation, that's all. So long as this regulation is in force, you are bound by that. And chartered accountants are not such people to pass anything they like. So you can't decide what parliament has decided is right. That is the first step. Once you make them and they don't comply, the contempt petition can be filed against him. Once contempt is admitted, they will lose their certificate of practice. The matter is solved completely. As you see that the presidents are made as chief executive officers. You can see even Sunil Talati, the father of past president, father of the current vice president, Aniket Talati ji, has written letters how to strengthen the structure, how it is being misused. That also we have shown it. I therefore request your friends, this is the letter I have written to the president and also all the members. And I request you to please read it and send suggestions to me. And we wanted to introduce auditor's appointment. We have to strengthen it. And let chartered accountants don't do audit because of the conflict of interest. 1. 2, let's have a whistleblower system and the way it should be processed. And 3, accountability on the president and the chairmen of each region. And regional council meeting SIRC should be done in video conferencing, where everybody throughout the southern region should participate, raise issues. Beforehand, they should send what their grievances, their branches, and let us give CPE hours for those things. That is the problem of our institute. Then once the transparency increases, the confidence of public will increase on the institute, and that will be the best thing that will happen, is my opinion. By 20th, you all have to give us these things. Then we can see. Thank you, friends. And